Oh, we had a huge hearing today in San Francisco, Northern District of California Federal Court. Judge Alsup, just this moment from the bench, issued an injunction requiring the Trump administration, based on the evidence presented so far, to rehire and stop firing probationary employees in 7 or 8 different agencies and departments of the government, because the judge found, in his words, that the Office of Personnel Management doesn't have the power to fire people, and that's exactly what they did. This sort of skirts the issue of the power of Elon Musk and Doge, puts it squarely on the entity that sent out the firing email, and has the judge now issuing the injunction after a hearing in his courtroom early, 8 a.m. California time, in which he entered the injunction. I'm Michael Popok. You're on Legal AF. Let's get back to it. This was already a battle royale because the judge ordered the acting head of the Office of Personnel Management, Charles Azel, to appear in his courtroom and give testimony, because Charles Azel put out a declaration under oath that said that he did not issue the firing order. And the judge is trying to get to the bottom of this opaque process by which people are getting fired and nobody's taking responsibility. The Trump administration freaked out and said that Azel is not showing up for his deposition or for the testimony in the courtroom because of quote unquote constitutional and executive branch privilege issues, which the judge already rejected. So the judge rejected Trump's arguments, ordered Azel to show up, and he didn't show up. We've got the Trump administration refusing to appear for federal court-ordered depositions and testimony. The judge went on without them and said at the hearing today, it is obvious from the record that the Office of Personnel Management has fired these people. They are to be rehired. It is more likely than not. It is the likelihood of success on the merits that this union that has brought this suit, the American Federation of Government Employees, AFGE, is going to win by showing that the firings were arbitrary and capricious, violate the Administrative Procedures Act, violate the collective bargaining agreements, violate constitutional principles. They're going to win. And the judge says, I had originally given an administrative stay. I'm going to give you a temporary restraining order from the bench. We'll get a written order soon, but I wanted to get on the air quick with this analysis. And the judge also noted that recently he approved the amendment to the lawsuit brought by this union to now originally it was against 8 different departments, the ones I listed, but now it's against all the departments and agencies of the federal government. And the judge says, well, for now, my order is going to apply to Veterans Affairs and Agriculture and Defense and Energy and Interior and Treasury, but I'm likely to expand it beyond that. Rehire those probationary workers, put them back in their jobs. He's going to have to separately deal with the fact that Azel, the acting OPM, flouted the judge's jurisdiction and is contumacious. That means he's committed contempt. And what are the penalties and sanctions for that? But the judge didn't let that stop him issuing his order as an Article 3 lifetime appointed judge. Now, there are multiple cases going on that we're keeping track of here on Legal AF and the Midas Touch Network, all sort of overlapping about the federal firings. I've just did a report about a new lawsuit and temporary restraining order about Donald Trump and the Department of Education trying to chloroform it or shrink it so small that it can be drowned in a bathtub. And there's going to be a lawsuit it has been a lawsuit filed with 20 different states. So what we're watching, we take the plane up 5,000 feet, dangerous as I know that is under the Trump administration, FAA. But if we do that and we look down, the landscape is as follows. You're seeing unions representing workers bringing lawsuits in places like California and in the New England area. You've got attorneys general banding together, 18 to 20 of them at a time, to stop federal firings and other type of lawsuits. And the blueprint for the complaint, the pleading that's filed to start a lawsuit is basically the same. It's that Donald Trump has violated the Administrative Procedures Act, which defines the actions that an agency head can or cannot take, and stops them from being what's called in the law arbitrary and capricious. So violations of the Administrative Procedures Act, violations of the Constitution, usually some version of the take care clause. The president doesn't make law. He has to execute the laws that Congress has established. And if he doesn't have his authority to do that, he's violated take care. He's violated the separations of power because he's self-aggrandized power for power that he's not entitled to as an Article 2 officer. And that he is ultra vires, meaning his conduct is outside the purview, the remit, the authority given to him by the Constitution and constitutional case law. That is the basic foundation of almost every suit you're going to have. Sometimes you see the First Amendment thrown in there, depending upon the type of case. But that is the basic building blocks for these lawsuits. And Judge Alsop, who was appointed by Clinton. He's a moderate, he's a liberal. Okay, the law is the law. And applying the law, they are now going to have to reinstate. What's going to happen next? They're going to take an emergency appeal off of this order once the order comes out in writing to the Ninth Circuit Court of Appeals. Not a friendly environment for the Trump administration. That's why the case was filed in the Northern District of California. We know how to file cases in the right courts too. It's not just a Republican thing. We know how to do it as Democrats and moderates too. So that'll go to the Ninth. It'll probably be a loser for Donald Trump to the Ninth, and then over to the United States Supreme Court about whether a federal judge, or as Sam Alito likes to say, the rightest of right-wing judges, does one single federal judge exercising lack of jurisdiction, having no jurisdiction, able to require the rehiring of 30,000 or 100,000 members of the federal workforce on the taxpayer dime? That's what you're going to see. I know people often write in my comments, Popok, don't give them any ideas. Trust me, this is already part of their playbook. They just go to the shelf and pull it. Oh, okay. That's what Alito just said recently in a case about Judge Ali in the District of Columbia about ordering $2 billion worth of U.S. aid to be immediately paid for already provided goods and services. So we're going to see it again. And now what's going to burst out into the open is once again, always comes down and reduces down to the same debate. The unitary presidential model, which is adopted, of course, by right-wing MAGA. They love it, love it, love it, love it. All power resides in the president of the United States, even against the checks and balance system that we've established. It's an imperial president, and it always has been, which is a lie. Then there's the other group of people that say that's a lie, that's a myth, that's used by people that want to do a power grab and violate the checks and balance and the three co-equal branches of government. I know there's 3 judges I know. I can tell you where 7 judges lie on that continuum on the Supreme Court right now. Ketanji Brown Jackson, Sotomayor, and Kagan, they don't believe in the unitary presidential model. Neither do I. And neither do most legitimate historical constitutional scholars. There's one group led by Steve Calabresi out of, I think, the University of Michigan or Chicago. He believes in that. And all of his minions and the Heritage Foundation, all that, they all line up behind him. But most thoughtful people believe in what Cass Sunstein has written in this area as a thought leader. But that's always been a myth and a lie. There's a reason we founded our country by getting away from the tyranny of a king. And we didn't want another king. And we built our government so there wouldn't be another king. Yeah, there had to be an executive, but not a king. And so that's the battle royale. 3 over here. And I can tell you now we're 4 more. Kavanaugh, Gorsuch, Alito, Thomas, they believe in the unitary president model because it benefits the president and their view of the world. And many of them worked in the executive branch, so they really believe it. Question for me is, where does Chief Justice Roberts and Amy Coney Barrett fit? I don't think, based on her prior writing and jurisprudential analysis, that Amy Coney Barrett is a unitary president person or a fan of that. So we got 4 and 4. Who's the tiebreaker? Chief Justice Roberts. And even though he's pro-president in a lot of different ways, and certainly at the immunity decision time, to immunize this president from any criminal conduct effectively and get him elected, I'm not sure he goes that far as to be an adherent to the unitary presidential model. This is exactly what's going to transpire at this doctrinal battle. Is for the soul of our democracy, the Supreme Court, and our constitutional republic. We just had Judge Beryl Howell last week in her writing reinstating the head of the NLRB, the National Labor Relations Board, and putting her back in her job, at least as a board member. She spent 4 pages in her order just talking about this theory and how it is at the core and animates the entire discussion before she even got to her particular case. And she's right. She's framed the issue correctly. So we're going to get this up to the United States Supreme Court on all of these issues in the next, 30, 60, 90 days. It's going to be an April, May, June event. Supreme Court's going to have to cancel their summer vacation and deal with these issues because they've got an out-of-control rogue president. And we'll follow it all right here on Legal AF, on the YouTube channel, on Legal AF, the podcast, every Wednesday and Saturday, 8 p.m. Eastern Time on the Midas Touch Network, on Popok Live, a new show I do on Tuesday nights on the Midas Touch Network at 8 p.m. Eastern Time, and on audio podcast platforms of your choice. Join us in all things Legal AF and me, Michael Popok. Until my next report. I'm Michael Popok, and I got some big news for our audience. Most of you know me as the co-founder of Midas Touch's Legal AF and the Legal AF YouTube channel, or as a 35-year national trial lawyer. Now, building on what we started together on Legal AF, I've launched a new law firm, the Popok Firm, dedicated to obtaining justice through compassionate and zealous legal representation. At the Popok Firm, we are focused on obtaining justice for those who have been injured or damaged by a life-altering event by securing the highest dollar recoveries. I've been tirelessly fighting for justice for the last 35 years, so my own law firm organically building on my Legal AF work just feels right. And I've handpicked a team of top-tier trial fighters and settlement experts throughout all 50 states known as big auto injury attorneys who have the know-how to beat heartless insurance companies, corporations, government entities, and their attorneys. Big Auto's attorneys working with my firm are rock stars in their respective states and collectively responsible for billions of dollars in recoveries. So if you or a loved one have been on the wrong side of a catastrophic auto, motor vehicle, rideshare, or truck accident, suffered a personal injury, or been the victim of medical malpractice, employment harassment or discrimination, or suffered a violation of your civil and constitutional rights, then contact the Popok Firm today at 1-877-POPOK-AF or by visiting my website at www.thepopokfirm.com and fill out a free case evaluation form. And if we determine that you have a case and you sign with us, we don't get paid unless you do. The Popok Firm, fighting for your justice every step of the way.